I'm joined by Harry Littman of the Talking Feds YouTube channel and the Talking Feds podcast. Harry, want to talk about the developments in the Manhattan District Attorney criminal case where Donald Trump was convicted on those 34 separate felony counts. Donald Trump went to the Second Circuit Court of Appeals to try to appeal federal Judge Hellerstein's denial of his attempt to take that state court conviction and where that proceeding is at, and then to move it in the federal court proceedings. Now, Donald Trump claims because my buddies at the Supreme Court made that absolute immunity ruling, now these are federal issues. So even though I was convicted in state court, I got to bring my state case now to federal court. Judge Hellerstein, can you take a look at this? And first, Judge Hellerstein said, nope, you didn't do the certificate of good cause. You have to ask me for permission. So I'm going to reject it on a technicality. Donald Trump then requests permission. Judge, please, can I do this? And then it says no. And then Judge Hellerstein denied it and said, nope, there's not good cause. Harry, then Donald Trump appeals to the Second Circuit. Tell us what happens and its import, please.
Okay, so, I mean, not a lot, and its import would be zero or less than zero, except the Second Circuit does just happen to be one level below the U.S. Supreme Court. And, you know, once burned, twice shy, or 5 times burned, 6 times shy. We always have to keep a lookout for that. So what he was asking to do with the removal, actually, this is one of the 8 times he threw stuff against the wall to see what would stick to defer the actual sentencing, to say he was going to be irreparably harmed by it. So the Second Circuit at this point said, you know, it's now off the docket. Merchan himself, on his own motion, decided, as we've talked about before, to move it over to November. And basically, there's nothing there. But Trump asked, after it happened, for a so-called administrative stay, except he styles it as a stay of the denial of removal, which, as you note, Ben, it's slicing the legal, deli kind of thin. But really what Hellerstein said was, you don't have any, I'm not even turning it down. You don't have a basis to come to me in the first place. He said that really both times. So in the Second Circuit, you have a request for an administrative stay of a sentencing that's already been put off, in a situation in which you're not supposed to be messing with criminal proceedings. That's a whole nother part of the federal state relations. And really, there's nothing to challenge anymore. But is there, what we always have to wonder, is there some way that it can be packaged to be brought up? And even though the case, I clerked up there, and you can't imagine a less attractive cert petition, try to say that Judge Hellerstein shouldn't have found there was no basis to remove. I mean, that is a picayune matter. And I personally do not think the Supreme Court will be messing with it. They don't need him to, or he doesn't need them to. He's not going to be having the sentencing, but he was going for broke in the Second Circuit, use it to just freeze the entire thing, as you say, because of immunity. Is there some teeny little read that the Supreme Court could use to try to make the next big bombshell of an announcement, going even farther and basically blowing the whole case out of the water so he's never sentenced? As I say, I don't see it. I don't think so. But anytime Trump is in the court just below the Supreme Court, one's paranoid legal mind, like mine, goes to scenarios that seem so far-fetched. But this is the Supreme Court we're now dealing with. So that's why you even sort of look at it and we talk about it now. Is there anything that to be nervous about? I don't think so. But they're one step from the Supreme Court, and they can easily bring, and probably will, a motion for cert, though it'll be the silliest looking thing ever.
In our legal jargon, sometimes we talk about the slippery slope argument. You open the door, and then the most drastic thing could possibly happen. Sometimes we refer to that as the parade of horribles. The thing with Donald Trump is when you think of the parade of horribles, you're not thinking in hypotheticals. You are realistically thinking actually how he's thinking. So anytime a court, whether it's the Supreme Court or whatever, gives him an inch, he takes the entire pie, if you will. And so the Supreme Court gave him the gift. We're going to basically create enough of a quagmire, even by adding things that you didn't ask for because your lawyers weren't even smart enough to think through these things, like evidentiary objections that would have dealt with this New York case. But the Supreme Court was like, this is my view. I'm not necessarily saying that you endorse this view, but I want to hear from you. But the Supreme Court's like, look, we'll agree to this concept of absolute immunity that you asked for. And without mentioning the New York case, they drop poison pills in their opinion, this idea of an evidentiary immunity as well, that the evidence itself of issues that could relate to core constitutional functions or official acts can't be introduced in cases. And so that derailed the sentencing. And I don't blame Justice Merchan. It's a quagmire that the Supreme Court, created. But then what does Donald Trump do? He immediately goes back to them and wants them to rule on the technicality of removing the case to federal court and whether or not Hellerstein should have found good cause in the first instance. So it goes to Hellerstein. By the way, and again, we're getting really geeky here, but then the district attorney's office would still have the opportunity, even if you get past that good cause threshold to file, to then seek a remand to bring it back on a full briefing and then another evidentiary hearing, right? And so what Trump's just doing, in my view, is delay, delay, delay. And the Supreme Court created this mess, and Trump's just so brazenly showing that he's didn't just spike the football after what they did. He wants to just totally almost delegitimize the court itself, it seems.
And the case. So it's really true what you say. He went for the whole, it's not just the cake, it's a double layer cake. What he was trying to do before was just postpone the sentencing, and that happened. But with this administrative stay, what he's been saying before, and Merchan is going to rule on this next month before he rules on immunity, is because there was some evidence at the trial that the Supreme Court, in the very bountiful opinion it gave him, said shouldn't have been heard. He wants to argue that Hope Hicks conversation shouldn't have been heard. If he were right there, he gets a new trial. It's hard to say because it's so picayune, but what he seems to be getting at now is, because of immunity, just freeze the whole thing, or that's a half step away from asking the Supreme Court essentially to take a broadside to the case based on immunity, but in a way that would make it go away and not give him a new trial. Anyway, that's the worry. Could he style a question presented that would actually give the Supreme Court, a whack at the entire case, as opposed to just the single trial in the entire case? And things get really crazy and bizarre once you get up to 1 First Street, where the Supreme Court is housed. And that's why only in the age of Trump would you give this a nanosecond of thought. But we're in the age of Trump with this Supreme Court, so you think, holy crap, is there anything he now can do with his, friends in the highest tribunal in the land?
Fair weather friends, though, in the sense of, as long as he continues to be the leader of the Republican Party, which is now the MAGA party or the Trump party, they'll be there. But I think what they've shown is that they're in it for power. And the realignment of the court to these right-wing Project 2025 style views, they view Trump as their empty vessel to accomplish their decades-long federalist goals. And Trump views them as his vessel to accomplish his get-out-of-jail-free card. That's, I think, the tension that we're going to see. I'll give you. Well,
that's a fantastic point, actually. I think that's a 3,000-word Atlantic article, everyone, that Ben's just giving you in 30 seconds. But that's right. It's not attention. I mean, they really, both of them have in different ways their eyes set on the administrative state, which they'd like, which Trump wants to emasculate and the court maybe wants to eliminate, for use two big SAT words. I just want to repeat where I started, though. We are getting super nerdy and down in the weeds in order to just conceive of some bizarro way the court could get its hooks in this. But my prediction is no, this is not going anywhere. The court won't touch it. It's just you always want to be able to, when we're in the era we're in, to at least think it through.
Harry Litman, Talking Feds YouTube channel, Talking Feds podcast. If you want to know where I get my legal news from, it's from the Talking Feds YouTube channel. So just go there. It's free to subscribe. They partner with the MeidasTouch network. Harry's the best out there. So please check it out. Thanks, Harry.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.